Let's proceed.
Good morning, Your Honors. Brian Decker arguing for the appellants today. With me is Leah Baralt, who represents the plaintiffs in the Armstrong case that's been consolidated. Paul Hines, who represents the plaintiffs in the Alpert case, is unable to be with us due to a death in the family. In this case, you are asked to, once again, determine whether a term in a collective bargaining agreement impermissibly conflicts with a statutory mandate, with a statute that is not listed in Chapter 150E, Section 7D. And just last year, as this Court noted in the Boston Housing Authority case, where a statute is not listed in 7D, the parties to a collective bargaining agreement are not free to alter its terms, and in that case, finding that an evergreen clause in a collective bargaining agreement, which the Court acknowledged was a helpful thing to the parties, was nevertheless impermissible.
Can I just ask you this question, though? The evergreen clause, helpful to the parties, yes, but there's another provision that the Court said it conflicted with, which expresses a public policy about 3-year contracts. This particular statute gives police officers a benefit, but it is a personal benefit. It's an increase in salary.
Yes.
They enter a collective bargaining agreement in which they agree to modify it, if you will. I gather,
Yes.
as a sort of, as a bargaining, as a point of bargaining in order for the city to actually sign up for the Quinn bill.
Correct.
Isn't that different? I mean, in other words, it's a personal, it's a statute, yes, but it's a personal benefit to them versus a larger public policy that it's helpful for the parties not to have to follow, but in doing that, they are violating a larger public policy.
Well, first to the point of that it's a personal benefit, I think it's because it's a personal individual benefit and that parties to a collective bargaining agreement are not free to bargain away all individual benefits of police officers. And
I understand, but it's a little different than something like bargaining away your anti-discrimination provision, it seems to me. It's salary.
It's salary, and just as the parties would not be free, for example, to bargain a wage that is $5 an hour, where the state establishes the state minimum wage at $8 an hour. This is a statute that provides for an educational benefit at a certain number. And in fact, in the BHA case, to go back to let me just say, with regards to the public policy that you raised, I think the court and the legislature have discussed clearly what the public policy is behind the Quinn bill. And the public policy of the Quinn bill is to advance the education of police officers for that greater good, for the idea that not only is it helpful to put more money in the pocket of police officers, but the actual public good and the public policy is educating police officers to provide better police services and to provide better services.
They are getting a benefit, though.
Well, they're not getting the benefit that the statute has mandated, which is the 10, 20, and 25. And unlike in the BHA case where this court found a conflict despite 30 years of precedent at the Labor Relations Commission, here the Labor Relations Commission precedent would support the plaintiff's position, where in Westport, as early as 1982, the Labor Relations Commission, now the Department of Labor Relations, I believe, said, regardless of the union's willingness to agree to the reduction, elimination, or other modification of the job benefit that is subject to Chapter 41, Section 108L, the union is powerless to do so under 150E.
Let me ask you this question, though. I mean, the statute has two important pieces. If you opt in,
yes,
you have to pay these benefits,
yes,
and you will be reimbursed at 50%. The statute doesn't deal at all with what happens if one piece falls out.
Well, actually, while the statute doesn't, this court very clearly did in interpreting the statute in 1993 in the Milton case. And what the court said in Milton was very clearly that when the legislature wrote shall be reimbursed, that the legislature meant shall, subject to appropriation, be reimbursed. And it's very clear that following that case, and in this case, the city of Boston adopted the statute 5 years after the Milton case in 1998. It was very clear to the parties, to all parties, that after 1993, it didn't mean shall be reimbursed anymore. In fact, while one could speculate that the reason that the city sought to have the modification that's at issue in the collective bargaining agreement was in direct response to the Milton case. And I'm not suggesting that it's not appropriate for the municipality to have attempted to address the uncertainty.
Well, in Milton, I mean, essentially the state couldn't be forced to pay.
Correct.
But that's a different question than whether or not the parties can bargain around what should happen if the state doesn't pay.
Well, and I think, Your Honor, that the parties are free to bargain around what happens if the state doesn't pay. They're just not free to bargain in a way that creates a modification of the primary obligation of the statute, which is to make these payments, whereas 10, 20, and 25%. So, for example, if a party were to have a collective bargaining provision that said, should the state, we know that Milton means that they don't really have to pay us back. Should the state not reimburse, then X, Y, or Z would happen. The contract will be reopened, and the parties will bargain to address that eventuality.
But in this case, if the statute had been written a little differently, if it had said, the city will pay the police officers this percentage,
yes,
and it will pay 50% of the Quinn bill amount, and the state will pay directly to the officers
yes,
the other 50%. Would
yes,
you be here making the same argument?
I don't believe I would.
Well, why? So why isn't the word reimburse here really a simple administrative convenience to the state rather than having to cut all these checks? It really has the operative effect of having two separate payors.
Because it really doesn't, Your Honor. Because what the statute is intending is that the payments be made. And if you look at the process and and it is described in our brief, what happens? The municipality adopts the law. The officers then, through the mechanism of the State Department of Education, have their degree certified. The municipality then makes payments once the degree is certified. And then once the payments are made in the subsequent fiscal year, it submits paperwork to the Commonwealth and receives the reimbursement for the expenditures that were made. Now, after Milton, we know that they can't count on the full amount that the statute says, 50%. But what it is doing, it is creating the obligation to pay, we would argue, is clearly separate from the reimbursement piece. And in fact, in the Rooney case, the court noted that, in fact, if a municipality fails to obtain the certification from the state, it still has to pay the officer. It just can't get the money back.
Is there any legislative history that would give us any insight into what the legislature anticipated would happen?
Well, I think that what the legislature intended would happen, there is not legislative history on what happens when the state doesn't fully reimburse, because I think prior to Milford, and certainly the municipalities in Milford were suggesting shall be...
Do you mean Milton?
I'm sorry?
Milton?
I'm sorry, Milton.
Yeah.
Yes, I'm sorry.
Okay, I just want...
Thank you. In Milton, the municipalities were of the opinion that shall be reimbursed meant shall be reimbursed. So it's only in 1993 when this court is clear that no, one legislature cannot bind a future legislature. And in fact, you always have to read subject to appropriation in any statutory mandate where the state is giving money, unlike where the state is making an obligation on a municipality to pay money, which is perfectly what they do in their statutes.
What happened in 1991 or 1992 when there wasn't reimbursement?
Well, in the Milton case, it is not clear whether the municipalities absorbed that and continued to pay the full amount, or whether the municipalities sought to pay the officers less.
But were there any collective bargaining agreements that addressed it the way this one does?
I do not know that, Your Honor. And I will say, again, speculating that, in fact, I would imagine that a lot of the collective bargaining agreements that contain language similar to this one arose after Milford, because they are addressing the uncertainty that Milford created. They're just doing it in a way that unfortunately creates a statutory conflict, and that this court is therefore required to apply the statute.
Mr. Decker, if you prevail, let's say you persuade us,
yes,
where's the money come from?
I believe, Your Honor, that the money comes from the municipalities. That the
Schools or wherever.
I have 2 children in the public schools. This is not something that I'm not sensitive to. And I also think, Your Honor, and I will say at least for the 3 unions representing the plaintiffs in these cases, all 3 are currently in collective bargaining for a successor agreement. And I wouldn't come here and suggest to you that this won't have a major substantive impact, whichever way the court decides, on the course of those negotiations, because all of a sudden now the municipality clearly does have to come up with some more money. In the case of Boston, it was $10 million plus that they were due, and it was $1.8 million they received. So, but
I take it, what year was this in the case? What year are we talking about here?
we're now into the 3rd year of the significant underfunding. The Milton case, I think, involved 3 or 4 years of less significant underfunding, but underfunding nonetheless. And I would also say, Your Honor, that is something that obviously will have to happen. But what the court is charged with doing is interpreting whether 7D would require the enforcement of the statute over the collective bargaining provisions. And in prior cases, that's been done without resort to, well, what will happen? In the BHA case, when this court invalidated evergreen provisions, I can tell you anecdotally that it has had a substantive impact on public sector labor relations and public sector collective bargaining. But the court did it because that's what it's compelled to do under 7D. And as this court has repeatedly said, the problem of limited resources is more properly resolved by the political and legislative process. The municipalities could go to, there's 3 things that could easily happen that I think are pointed out in one of the amicus briefs, the one of the Mass Coalition of Police. The municipality would be free to revoke the Quinn Bill, which, is certainly not something that my clients would like to see happen. But following the Westport case, it's clear that they can do without bargaining.
What would that mean, to revoke the Quinn Bill? Aren't the municipalities still on the hook for all the people who are certified?
Well, then to be honest, Your Honor, I think we would end up in litigation over the implications of what it would mean to revoke the Quinn Bill. I think it's under Chapter 4, the way any other local option law would be. But the decision to do so, it would be the municipalities alone. They don't have to bargain with us about it, again, because we're not free to create that bargaining obligation.
Isn't the Quinn Bill basically limited duration going forward? I mean, no new people are
being
covered by this.
It is, Your Honor. That's
so we're talking about a set of people who are basically already qualified.
Already qualified and in fact, shrinking, because as people with Quinn Bill benefits retire, they're replaced with people without Quinn Bill benefits.
So it's a finite group. And
it is a finite group.
I'm having difficulty understanding what revoking the Quinn Bill would do for the cities.
Well, I think it would create, again, that would put us back at the bargaining table as well, but the city would have the right to do it. I believe the officers would no longer have a statutory ability to receive the benefits, at least statutorily. And if you, as is noted in the amicus briefs, many municipalities have addressed this problem through collective bargaining, ways around it. In fact, the Falmouth case, which was scheduled to be heard subsequent to this case this very morning, was settled on last week. I actually learned about it from the clerk. Because the parties came together, they bargained around this problem. They bargained a way to accommodate the local aid cut, which is what we're really talking about, a local aid cut. They found a way to negotiate that without contravening the requirements of the statute. And as the amicus's note, many municipalities have negotiated ways to maintain the full benefit to the police.
So you said there were 3 options that...
I'm sorry. The second option, the other 2 options would be legislative. And the municipalities could go to the general court, and I think there's 2 ways to address this and to make these collective bargaining provisions permissible. One would be to amend 150E Section 7D to list the Quinn Bill as a statute that the parties are free to amend or modify through collective bargaining. The other would be to amend the Quinn Bill itself in the manner that Justice Spina indicated, which would say instead of the officer shall be entitled to 10, 20, or 25, the officer shall be entitled to 5 plus whatever the state sees fit to reimburse us.
But do you agree that when the legislature passed the Quinn Bill, it did not anticipate that the word shall reimburse may turn out to be shall reimburse subject to appropriation, that was not in their minds when they passed it?
It may not have been in their minds, Your Honor, but it certainly was something that this court in the Milton case says should have been in their minds, because
but try my question.
Yes.
In terms of legislative intent, is it your view that they understood that the word shall did not mean shall?
I don't know that, Your Honor. I would imagine that they did. However, since 1993, there have been ample opportunities for a legislative amendment, and there has not been one.
I guess the last question was, if you prevail, you articulate that we could have a mess in terms of cities deciding whether or not they're going to try to opt out and the consequences of all that, all of which would be contrary to what the legislature intended in terms of the benefits provided by the Quinn Bill. Why should we assume that the legislature intended a system which would create this problem?
I guess I misspoke. I didn't indicate. I believe I suggested that it would engender litigation were a municipality to opt out and what kind of obligations that creates. If we were to prevail in this case, I think it would put us, to be honest with you, right back where the unions will be, whether we prevail or not, which is bargaining with municipalities as to how to deal with a local aid cut, just like the unions and municipalities are dealing with the other couple $2 billion in local aid cuts that have been part of this fiscal crisis we're in. But the issue for the court today is not how do we deal with a fiscal crisis, it's is there a conflict between the collective bargaining agreements as the parties have fashioned them and the mandates of the statute.
Mr. Decker, your time is up.
Thank you very much.
Good morning, Your Honors. May it please the Court. My name is Kay Hodgen with John Simon. We represent the City of Boston and the defendants in this matter. And I'd just like to point out that in terms of the facts of this case, which are upon an agreed statement, that that in this matter, the unions representing the 4 different groups of employees, and all four groups of plaintiffs are represented by a union, agreed to language that if the Commonwealth did not fully fund the 50% obligation under the Quinn Bill, that the city's obligation would in fact be its 50% share.
But why does it matter? I mean, why is that even relevant?
Well, Your Honor, I think that as a just as a legal matter, this court is restricted, or this court certainly has adopted over time, a restriction on its ability to make changes to legislative pronouncements or statutes to those situations in which there is a direct conflict or a material conflict between a statute and a collective bargaining agreement.
Yeah, if there's a collective bargaining agreement, by definition, the parties have agreed to something, and we still look at whether there's a conflict between the statute and the collective.
But the question here in this case is this, and I would suggest the following. If the statute operates as anticipated, which is 100% funding, this is 50% from the Commonwealth and 50% from the city or town, then in fact, then an individual gets the 10, 20, and 25% increase based upon education. But the city's share is 5, 10, and 12.5%.
Well,
that is what is provided in the collective bargaining agreement.
That's contrary to Milton, isn't it?
Yeah.
No, it's not. My reading of Milton, and obviously it's the decision of this court, and you can disagree with my reading, but I think that Milton does not make any major pronouncements about the Quinn Bill. What it basically is a case which says, as a matter of constitutional separation of powers, individual cities and towns cannot sue the Commonwealth and force it to make payments. It is subject to appropriations. I mean, that is, and there is, in fact, that is the essence of the way I read Milton. So I don't believe
So who
that
was
Milton
left
says
paying
that.
the bill in Milton? Who was left paying the full bill in Milton?
In
Or
fact,
in
that
Rooney.
case did not arise, as far as I understand it. If the Commonwealth had not paid, I believe in Milton for a couple of years, and I am not as familiar with that history factually, but I would assume that that either it went unpaid or it was paid for by the city or town. In this instance, obviously, as far as my client is concerned, the city of Boston, I think it's important to recognize that having looked at the Milton case and having obviously a request by the unions to join in on incentive payments for additional education for its police officers, The city was willing to do that, but willing to do that only if there was a clear understanding regarding what its obligations would be. And I would suggest to you that this is a matter of the silence of the statute. You have two parts of the statute. One part says...
Can I ask you
Yes.
on that very question, if we were to accept the police interpretation of the Quinn bill on those two, that the obligation to provide benefits is separate from the obligation of the legislature to reimburse, if we were to accept that, is there any way that the Quinn bill does not conflict with 7D?
Your Honor, it's my view, again.
I know you say that's not the interpretation we should adopt, but I'm just saying, don't those things go together?
No, I don't
Okay,
believe
tell
so.
me how the Quinn bill would not conflict if we agreed with the police interpretation of the statute. How would the Quinn bill then not be in material conflict with the collective bargaining agreement, and therefore under 7D, the collective bargaining agreement is trumped by the statute?
I think you have to begin, or at least I begin my analysis, by looking at Chapter 41, Section 108L, the Quinn bill statute. You have to look at the statute itself.
Right.
Does the statute answer the question, what happens if the Commonwealth does not pay? It does not. Now, that having been said, it is clear the legislature drafted a statute with two shells. In one respect, they said the Commonwealth shall reimburse, and in another respect, they said that the payment should be the payment should be the benefit levels that were in fact provided.
But that's not the question I'm asking you.
Okay.
The question I'm asking you is not your interpretation of the statute.
Correct.
The police interpretation of the statute.
Okay.
Let's say we agree with that.
Okay.
Is there any way, because you also argue that there's no material conflict with with 7D.
Okay.
On your interpretation of the statute, there's no material conflict with 7D. I'm saying if we agree with the police interpretation, how is it not in conflict with 7D?
Well, my view is that 7D does not set up a separate conflict standard of review for this court. What 7D is about is it's about allowing collective bargaining agreements to supersede a set of laws that are listed in 7D. And besides that, it says that collective bargaining agreements cannot conflict with law. And I think that that is what this court does every day. This court looks at acts and looks at language and makes a determination if the particular act or language violates in any way an existing statute. I do not believe that 7D sets up a separate standard. If you believe that it sets a separate standard, then obviously my client loses in this matter. But the fact of the matter is, because the statute says in the one shell, the benefit level is established. My point is this. The benefit level anticipated by the legislature to be paid by the municipality was its 50% share. And for years, it has been exactly that. The amount of the benefit received by the individual employee, the individual police officer who received education, was for an associate's degree 5%, was for a bachelor's degree 10%, and was for a master's degree 12.5%. That is what was practically happening, and that is in fact what is in the statute itself. And it would be our position that that what the collective bargaining agreement does is it fills a gap. I would suggest to you that based upon this court's regular admonition that you will interpret both collective bargaining agreements and statutes to be a harmonious whole, I would suggest the following. There are many instances in which statutes do not anticipate all of the various impacts or effects that they might have. It is therefore left to collective bargaining to in fact resolve those and to fill those gaps. I would suggest in this matter, to the extent that the legislature hasn't addressed what happens when they don't fund this particular, their 50% share, that this is what the parties agreed to, because you look at Chapter 150E and the obligations under Section 6 to collectively bargain about wages, hours, and working conditions, of which incentive payments are an element. But as Justice Botford's, I believe, pointed out, they're different in kind, and I believe it was your Rooney case, Rooney versus Yarmouth, which indicated that these specific incentive payments are different in kind than are the mandatory minimum wage requirements that exist in other parts of the statute or discrimination statutes.
I'm speaking not from having looked at this recently, but I believe that many of the education statutes, having nothing to do with collective bargaining, but sort of cities and towns are required, for example, to fund special education. And part of the statutory scheme is that the Commonwealth will reimburse, I think, up to 50%. It's some percent. Commonwealth often doesn't. City and town still has to do that. Why would this be different?
Your Honor, I think that there are a couple of things. Number one, the statutory scheme is different, and the language that's used in those statutes are different, but also because of the federal mandate. The money that is often given to cities and towns flows through the federal government under the IDEA, which is the standing here, I forget, but in any event, there are 2 or 3 federal statutes that actually require the special education services be provided and that fund to the state for some of those services. And if they don't provide wholly, I mean, in other words, a city or town could not just say, we're not going to do this, because they do receive federal funding for much of what it does. Here, the money, the 50% share of the Commonwealth comes entirely from the Commonwealth. And I suggest, based upon certainly the analysis that we have provided to you, that there is no conflict. And the conflict standard is a very high standard. I would remind you that the conflict standard is a direct and substantial or a material conflict. And here, where there's silence, that you can look to Chapter 150E and look to it as a way in which to resolve the particular conflict that you have before you. The last thing I would point out is basically, when the city of Boston adopted the Quinn Bill or moved, to accept the Quinn Bill after Milton, it did so in a package. And if you read the stipulated facts and also the attached documents that are referred to, it was all a package. What the city agreed to was the city would agree to adopt the Quinn Bill with the understanding that if the Commonwealth did not pay, then its obligations would be limited. In addition, it agreed that in the event the Quinn Bill were even repealed, that it would continue to make that its 50% contribution. And I suggest to you that that is what the legislature intended if you take the broadest view of all of the statutes, which include not only this statute, which has, as I pointed out, the gap, but also the collective bargaining statute, which is Chapter 150E. And it is in that context that we argue to this court to reject the plaintiff's position and to adopt the position that is articulated in our brief.
But what you're asking us to decide will affect communities where maybe that wasn't part of the original bargain, but it has been worked into collective bargaining agreements. So it doesn't matter really what the original bargain was, does it?
Oh, I think it does. I mean, I think yes and no. I mean, I think that what you're going to have is there are numerous communities throughout the Commonwealth who, in fact, have exactly what the city of Boston has. Exactly. And the fact of the matter is they're going to be stuck with it. If you agree with the plaintiffs, they're going to be stuck with a very significant bill, which, as you know, money is money, and it will have to come from somewhere if that is the decision of this court. On the other hand, I would suggest to you that you need to look at the statute, because this court has really moved, I mean, in all of its decisions, and I do hear plaintiff's counsel referring specifically to a case, as many of you may recall, I argued in the Boston Housing Authority. That is exactly the example I give. It isn't because of 7D that you decided the Boston Housing Authority. It is because Section 7A of Chapter 150E says collective bargaining agreements should not exist for longer than 3 years, and the facts were that the particular evergreen clause at issue forced the collective bargaining agreement to exist for longer than 3 years. The point is I think this court faces this decision regularly, And if you place any if you seek to take the interpretation, I would suggest to you it would raise significant questions about any future issue. I mean, while I think the legislature has in fact limited the impact of the Quinn bill as we see it today, the fact of the matter is that the legislature often has situations in which it wishes to incent cities and towns to do something that they perceive is good for the public interest. I happen to believe, and my client, the City of Boston, certainly believes that further educating its police force is a positive good. However, the fact of the matter is there are a lot of positive goods that have to be resolved within the limited economic sphere. But if it turns out that this local option adoption suddenly means that it is susceptible to gotcha should the Commonwealth decide that its fiscal circumstances do not allow payment and allows a shifting of the cost of that to the city or town, I don't think cities and towns are going to adopt very many of these local options, and a means for addressing issues that certainly the legislature and the Commonwealth believe are legitimate and important will no longer be an effective tool.
Is there any way that we can get better insight into what the legislature might have intended in these circumstances, or is the record just purely silent on the subject?
Unfortunately, Your Honor, if it had been there, we would have cited it. But unfortunately, we were unable to find any particular legislative history for this particular.
So we have to figure out what the legislature would have done had it thought of this possibility? Or are you saying we should devise what you think to be the better public policy right now?
Oh, I don't believe it necessarily has to turn to public policy. I think you look at the words in the statute, and you see that that it is silent on the question of what you do when the Commonwealth does not pay. You look at the typical words, and as we cite in our brief, the word, quote, reimburse does not have the implication that the plaintiffs would ask you to have, which is significance beyond the fact that it is an administrative convenience, and that is what we argue. We argue specifically the fact that you look at the words in the statute, the only word upon which the plaintiffs are relying, I believe, is the word, quote, reimburse, which we argue is formal.
No, they're focusing on the word shall, which is a pretty good word for them.
Yeah, no, I don't disagree with you, Your Honor, but then that gets back to the argument that we have posited, which is it says the Commonwealth shall reimburse. So it seems to me, as I started my argument here, we really have a statute that has two very important shells in it. And the question is, when it doesn't address what happens in the, in that space, the gap, as I put it, then the fact of the matter is under this larger statutory scheme, which includes Chapter 150E, the parties have in fact resolved that, and I suggest that that's where the resolution ought to rest. Thank you very much.
We'll have to leave it there. Thank you.
Thank you.